Hello, everybody, and welcome. It's my first live of September. So you might want to say it's my first live of fall, correct? We're heading on down to the winter months to the end of the year, and pretty soon it's going to be 2025. Hard to believe. I know. It just keeps going and going and going and going. But yet I keep getting younger. Just kidding. Anyway, as you know, in the month of September, I'm going to talk about guardianship proceedings, guardianship and incapacity. Now, today I want to focus on the incapacity proceeding involved with the guardianship proceeding because there's two cases that we deal with when we deal with a guardianship. The number one case is an incapacity case. The number two case is the guardianship. I'm going to put the guardianship down here for now, but I'm going to address the incapacity proceeding because that's the number one case. That's the case that's most important. That determines whether or not an individual truly needs a guardian. What is the individual capable of doing on their own or not capable of doing on their own, where they need somebody appointed to take care of those rights that they're unable to do? So, in an incapacity proceeding, we file a petition for incapacity. And in that petition, we have to list exactly what that person suffers from that does not allow them to make decisions. And when we talk about decisions, the decisions that we are specifically addressing are the rights to have a driver's license, the right to vote, the right to marry, the right to contract and sue, the right to make medical decisions, the right to know where to live, the right to travel, the right to apply for medical benefits or decide or medical and financial benefits, and the ability of them to take care of their finances. Those are the big things that we look at when we file the petition to determine incapacity. And we point that out in the petition. So when we file it, it's kind of a roadmap to where the court can look at it. So once we file that, then we request the court to appoint examining committee members. What are examining committee members and what do they do? By law, the court has to appoint 3 examining committee members. Now, again, this is the state of Florida. I don't know what it's like in other states, but this is the state of Florida. We appoint, or the court appoints, 3 examining committee members. Now, in those 3 examining committee members, you have to have at least a psychiatrist or somebody with a medical doctor, an MD after their name. 1 out of the 3 has to have that. Otherwise, you have an incomplete examining committee. So you have to make sure, the court makes sure that they appoint 1 MD, 1 psychiatrist to take care of that. Now, the other 2 can be a psychologist, a social worker, a nurse, licensed mental health counselor, somebody with a degree maybe in gerontology, somebody that has the advanced degree, the advanced knowledge to know how to evaluate an individual for their medical needs, their medical and their psychiatric. Are they able to make decisions? Can we do an assessment on this individual? Do I have the education and the knowledge to do an assessment on an individual to know whether or not they can make decisions for themselves? Now, let me give you an example. I am a licensed clinical social worker. Before I became an attorney, I have my bachelor's degree in social work and my master's degree in social work, and then I became licensed. I worked in nursing homes for 10 years. Do you think, without my law degree, I would qualify as examining committee member? Of course I would. And in fact, before I became an attorney, I was on the examining committee. And I did go out and see individuals to assess them for capacity. And I had to file a report. Case in point, the examining committee doesn't just go out and say, yeah, I think they're incapacitated. Yeah, Your Honor, I believe they're incapacitated. No, they have to do a report. In that report, they have to address what the person suffers from, what their functional ability is, what their mental ability is, what their ability to communicate, all of that. They have to go into detail in regards to that. So they have to do an evaluation of that person. Now, as you know, since COVID, we've gotten so comfortable with the video assessments, right? So the court does allow for the examining committee to do a video one-on-one with that individual to assess them, to, there's a mini mental, to do a mini mental on them, see what they score, do other tests on them to see what they score, and put that in their evaluation. Then finally in their evaluation, they have to check what rights they feel that individual can or cannot keep, and what level of guardianship they need. Do they need a full-on guardianship, somebody to take care of everything for them? Or is it a limited? Well, I think they can't do this, but they can do this. So they have to recommend that. Or they can say, we don't believe this person needs a guardian at all. They are totally competent, totally able to make their own decisions. So those are the things that are included in their report to the court. Now, does the incapacitated, or we call them the alleged incapacitated person, AIP, before they're determined potentially incapacitated, we call them an AIP. So before the examining committee is even appointed, they appoint this AIP an attorney. That attorney is court appointed to protect the ward and make sure that they're taken care of. Oh, hi, Fabian. How are you? And again, a beautiful beach scene. I love it. Hello, Attorney Laura Sterling. I have a question. Can my own doctor be a part of the examining committee? Excellent question. I get this all the time from family members. Well, my loved one has a doctor. Why can't I just get a report from them? No. The court looks at it. It has to be 3 independent, non-related, non-associated with the AIP members. So their doctor cannot come in and write a report, submit it to the court, and it would be accepted as part of the examining committee. No, unless good cause is shown. Maybe there's no doctors on the list. There's no doctors on the list for the judge to appoint, so they have to go with maybe the doctor of the AIP. But they prefer not to do that because they want somebody that has a total fresh mind, knows nothing about this AIP, and can give a full and honest appraisal of the individual without any background. Now, the member of the examining committee, of course, can contact the family doctor to get a background and to say, okay, what's going on, ask questions. But the family physician, unless good cause is shown to the court, can be appointed on the examining committee. So excellent question, Fabian. Thank you so much, because I do get that a lot from family members. So back to the attorney. Now, the attorney for the alleged incapacitated person must be appointed by the court. Now, of course, the AIP can certainly appoint or can go on and hire their own attorney to replace that one appointed by the court. But the reason for that is because when you're determining somebody to be incapacitated, you're taking away constitutional rights. So the court has to appoint an attorney to that individual to protect their rights. And that individual's job as their attorney is to advocate for their client. Regardless of what, as an attorney, we think of our clients or we think our clients should do or not do, they're there to advocate for that person, for that AIP. So if they meet with the AIP and the AIP says, I don't want a guardianship, I don't think I need a guardianship, the attorney may feel in their heart, oh my goodness, this person really does need a guardian. But guess what? They're an advocate for their client, just like I am, just like any other attorney is. And they have to present to the court that the alleged incapacitated person objects to a guardian being appointed. And then one of two things may happen. We have a full-on evidentiary hearing, or we just have a 30-minute hearing where the alleged incapacitated person can give their thoughts. I recently had a 2-hour evidentiary hearing on an incapacity, and we had to have the examining committee members who completed their reports and gave their opinion testify as to where they got that opinion, what did they do, what did they think, why, and so on, to just give testimony to talk about their reports and to emphasize their reports to the court as to why this individual should be appointed or should be determined to be incapacitated and appointed a guardian to take care of their needs. So that's what the attorney does for the alleged incapacitated person. They're there to advocate. They're not there to be against anybody. They're not, I get family members all the time because I used to be that attorney that was appointed for the alleged incapacitated person. People would get mad at me like I'm fighting them or against them. I'm not against anybody. I'm for my client. I'm not against anyone. I'm for my client. That's what I would continually say. You're not my client, sister, brother, cousin, mother, dad, whatever. My client is the alleged incapacitated person, and my job is to advocate for them. One time I went to somebody's house. I had to see the alleged incapacitated person because they were living in the house. They took me to his bedroom. Oh my gosh, very nice. The man was very well taken care of. The family wanted to, they wanted to hang out. They wanted to find out what was happening. I said, I need you to leave the room. Yeah, I need you to leave the room. This is confidential. Me talking to my client is confidential. I need you to step out. They weren't happy. Yeah, I'm not there to make them happy. I'm there to represent the client. My client, the alleged incapacitated person. So that's what I'm there for. So I did it. He was fine. I recommended a guardian. I left, and that's what happened. So, oh, hi, Floor. How are you? Happy Monday. Yes, happy Monday to my fans. I'm usually not here on a Monday, so I want to welcome you. What is the difference between incapacitated and unable to make decisions? Very good question. I get that all the time. We do a lot of work for hospitals and nursing homes, and the hospitals and nursing homes say, well, the doctor says they're incapable of making decisions, so they're incapacitated. Not in my world. In medical world, yeah, you can have a doctor come in and say, yes, they're unable to make decisions. They're incompetent. They can't make their own decisions. What I'm doing in a court of law is I'm getting them legally determined incapacitated. So they can't sign up for a credit card. They can't go buy a car. They can't consent to somebody getting their medical records. They can't. Legally, I'm getting them adjudicated incapacitated. That's different than in a hospital. In a hospital, if they're determined not to make medical decisions by the doctor there, well, okay, so they don't make medical decisions. They can get somebody, a family member, to do that. But once they leave that hospital, they're still able to sign contracts, sign up for a credit card, buy a car, whatever. And you don't want them doing that if they really can't. So that's what I'm doing. I'm getting them adjudicated, legally incapacitated, so they can't do any of those things that the guardian is stepping in. And that's to protect that person so that they're not being taken advantage of. So that's our job. But excellent question, Flora. Excellent. I get it all the time, so I appreciate the question. Anyway, so that's what the incapacity is. So once, let's say the person is determined incapacitated, now the court determines they're legally incapacitated, closes that case now, and now has to move to the guardianship case, because you can't leave somebody out there that's been adjudicated incapacitated without somebody to take care of them. But we're going to talk about that at my next live, which will be September 25th at 2:00. We're going to talk about the guardianship and how they're appointed and what makes you eligible or not eligible to be a guardian. So thank you so much for tuning in. We'll see you on the 25th at 2:00.